Welcome to Deals and Disputes with the West Webb Law Group.
Hello and welcome to today's episode of Deals and Disputes with West Webb Allbritton and Gentry, where today we're going to dive into higher education law and how that all affects the world today. So, Gaines, what's going on? Welcome.
Hey, good to be here. Always to see our viewers on I think, a really important topic.
Yeah, for sure. I think I forgot to say your full name. Gaines West is here. He's a partner at West Webb Law, at West Webb Allbritton and Gentry. So I'm excited to talk about this. It's a little different topic than we've done thus far. How did you get into practicing higher ed law? And can you kind of explain exactly what that encompasses?
Absolutely. The fun thing about this is it makes me go back and remember when John Webb and I started dreaming about starting this firm, because I was at the general counsel's office for the Texas A&M system. I was there for almost 4 years and left as their associate general counsel. And in that 4 years, I got a heavy dose of what I call higher education law. That's dealing with professors, professional students, staff members. It deals with issues like tenure, tenure denial, discrimination, retaliation, all kinds of issues that, you wouldn't think that you would need legal help until you're one of those professors, one of those staff members, one of those professional students who really want a due process. And they want to be able to get their story out there. They want someone to believe them. And that's where I learned my street creds, I guess, on higher education law was back when I was working for the Texas A&M system. So what is higher education law? It is an amalgamation of a number of topics. I've named a few of them. But basically what it is what we experience in the workplace, but just put in a higher education setting. This isn't like education law is dealt with in disabled students, say in high school or in elementary school. This really deals with your highest echelon of faculty member, professional student, staff members who feel like they've gotten a raw deal or getting a raw deal. Now, I have had the opportunity also to work for smaller colleges and universities. And so I've been on both sides of this. And it's very interesting to see all these issues from both sides of the docket. Primarily, though, I'm going to represent the faculty, staff, student who feels they've been wronged. So higher education law is something that I wind up having to teach to judges all the time because, higher education is looked at like an ivory tower experience. And after all, it's the educators out at universities and colleges across the state and across the nation. As a matter of fact, I represent people outside the state of Texas, and we go all across the state of Texas. I've litigated and represented faculty, staff, and students at primarily basically all of the state public institutions and many of our private institutions. So what I do when I'm teaching a judge about higher education law, you have to do that, carefully and with tongue in cheek that you're teaching a judge anything. But I do my best to explain that the same principles that go along with protections for employees in the private market are really no different in higher education law, because there's a little bit of a bias out there, I think, in the judiciary to conclude that, look, whatever they do in that ivory tower, I don't want to look at. They're training people up and they're the best people to decide what to do with someone. Well, that's not altogether true, because an institutional client, whether it be a private or public, is still restricted by our laws. And so it's always a challenge to bring new information into the courtroom and to say, let's treat this just like any other case. And so that's why I've loved it over the years. I've been doing this for probably a total of almost 35 years or more. I've been practicing law for 51 years. And out of that, I really started doing employment law in higher education settings before we had a lot of employment law out there or employment protections. I was dealing basically with the 1976 Rehabilitation Act and not the ADA. We didn't have the ADA yet. We didn't have the protections for the Equal Pay Act. We didn't have discrimination protections. We had Title VII of the 1964 Civil Rights Act that protected against discrimination, but it was still in its nascent stage of being applied everywhere, not the least of which was in a higher education setting. So, as I said, it's an amalgamation of topics, but you take really most everything that I deal with in the employment scenario and put it into the higher education scene to come up with some protections.
Safe to say you're an Aggies fan?
I am an Aggies fan. I am not a former student. I'm a Baylor Bear. We've lived in this. Yeah, we've lived in this city since 1978, and it's a great town. This is a great institution here. Yeah. Not different than many of our large state institutions, not only across this state and across our nation, but just like any institution, it's made up of people, a lot of people. And there's some segments of those groups that do better than others. Bill Mobley, who used to be he was department chair of management, then he went on to the presidency and then chancellor. And he used to ask me, he said, Wes, why don't you ever represent us? And I said, well, I'm having too much fun holding you accountable, Bill, to all the things that you say you are and you do. And I said, and secondly, you probably couldn't afford me anyway. So we would have a good laugh. We'd have a good laugh over that. But higher education law, to me, is a great challenging area, and a great area where people need to be treated equally and fairly, and provided protection when they need protection.
What do you consider differently for a case against a private university as opposed to a public university?
Well, in Texas, we have both, of course. And a public university is created by the state of Texas, and they have something called sovereign immunity. And sovereign immunity is sometimes an almost impenetrable wall to get through or over. For private universities, we're dealing with contract terms normally. So many of my clients over the years who have come to University of Texas, Texas Tech, A&M, University of Houston, other major colleges around the state, and they've come from out of state, and they bring their letter from the institution that says this is a contract, and in this contract, what we're providing you is a promise to get maybe 5,000 square feet of lab space, and they show up at the institution and they get 1,000 square feet. I've heard it looks like a closet in comparison to what they promised me. I want to sue them on this contract. Well, the problem is you can't contract with the state of Texas. The only group who can bind the state of Texas is the legislature. And you say, now, wait a minute. That doesn't make sense, Gaines, because I've heard that Jimbo Fisher has to be paid $75 jillion or something on his buyout. Well, that's only because A&M wants to do it. Years ago, the coach out at Texas Tech, Mr. Leach, left that football venue and sued Texas Tech on his contract. And he made it past the trial court, but he didn't make it past the appellate court because the appellate court said, hey, by the way, you cannot sue the state of Texas unless they give you their permission. And their permission only comes from the legislature. So the reason that Texas A&M and other large universities go ahead and honor those contracts with football coaches is because if they don't, they won't get another one. Mm-hmm. But they don't feel the same compelling motive to provide 5,000 square feet of lab space when they promised that in a contract type document. But when you get here, it's only 1,000. They don't have to do anything, and you really can't do anything about that. So what I spend a lot of time doing with my clients when they come in and they have grievances and problems is if it's a public institution, I put them into silos of remedies that we might be able to use in order to get the attention of the college university. But with private universities, I'm looking at, based on basic contract principles and breach of contract principles, that allow you to bring a lawsuit within 4 years for breaching that agreement. So there's a big, big difference between a public institution of higher education and a private institution of higher education, because we just have to use very different resources and able to get the attention of the university to have them finally do what we want them to do instead of what they want to do.
Mm-hmm. When it comes to discrimination claims, what laws need to be followed in order to file one of those?
Again, our state and federal government have provided discriminatory protection for employees, but it is quite a undertaking to figure out what to do and when to do it, and whether to file your claim only with the university or with the state or federal government. In Texas, we're called a state that complies with both Texas Workforce Commission rules and the EEOC. As such a state, when a complaint gets filed with the Texas Workforce Commission Civil Rights Division, I'm going to call it TWC CRD. That's our acronym. That's the way we refer to it all the time. We're what's called a dual filing state. So if I file that claim for discrimination within 180 days of the discrimination happening, I'm automatically filed with the EEOC as well. That has to be the gateway through which any claim I might make for the client has to go through before it can ever go to litigation. The law allows us to, allows the state and private entity to investigate the claim, see if it could be resolved through mediation. And if not, and their investigation continues on, then they issue eventually what's called a right to sue letter. If you get one from the state, you've got 60 days within which to file a lawsuit in the state district court. If you get one from the federal government, from the EEOC, you've got 90 days within which to file that lawsuit in a federal court. So it's hard to know exactly when to file, what to say when you file, because there are a number of traps that an unsuspecting employee can fall into if they don't know how to fill out that form and do it well. So they need help. I'm not here to say, just use me. You need help, though. Don't try to do this on your own.
And what other similar claims protect employees in higher ed?
Well, we've had a recent one. It's, the Labor Code 21141 has that's a Texas Labor Code, just the code provision dealing with sexual harassment. And that's a fairly new provision that applies to all employers in the state of Texas, as long as you have one employee. That's it. These other discrimination claims, you have to have 15 employees for the Title VII discrimination protections to apply. But in the state of Texas, we have this new provision that says if you've been sexually harassed, you have 300 days within which to file with the Texas Workforce Commission Civil Rights Division. You remember I just said there was a 180-day filing requirement with the TWC CRD, but there's also a 300-day filing requirement with the EEOC. So if you miss that 180 days, you can still file with the EEOC. One of the problems we have in this area, though, is just the sheer cost of being able to litigate against a large institutional client. Mm-hmm. The institutional client, if it's private, usually hires an outside law firm, pays them big money over a long period of time to represent the university. If you're a state institution like University of Texas or Texas A&M, Texas Tech, University of Houston, you have the forces of the Attorney General available to you. They assign you a lawyer. It's free to the university. So they're able to skate along without having to spend any money out of their pockets or being concerned about the cost of this litigation to them. Private institutions have to worry a little bit about that cost, but they're still a big institutional client and have put a lot of money aside for the purpose of defending lawsuits. But the main thing that we're concerned about when it's a public institution you may be litigating against is just the ability to stand in there, because one of the ways in employment litigation, when I'm on the defensive side, I'm just going to hang that employee out to dry as best I can and make them have to spend money until they run out of money. The college or university doesn't care how they win if they can drive you away by simply making you spend so much money you can't go on. They'll do that. Learned that back when I was working in the general counsel's office so many years ago. So there's a lot of tricks, hidden tricks to this game, and you really need to have a guide to get through some of these issues, to understand what your options are. One of the things that I've always tried to do successfully is to have my client understand their options. If I can't explain their options in simple terms to them so they can decide what's best for them, I don't have any reason or shouldn't be going to the courtroom, because I've got to simplify very complex issues for a jury to understand.
Right.
So my first hurdle is to get that information to my client so that when they make that decision of what they want to do, it could be they've decided they don't want to go forward because they don't want to spend the money. It could be that, they're concerned if they litigate with their current employer, how does that affect their future job hunting capability?
Sure. Yeah.
Many of my higher education clients, though, tend to be later in years, endowed professors who are protecting their reputation through the many decades. They seem to have a large disposable income, and they just want to make sure that they finish well and finish right. And so those are the kind of claims that oftentimes will go into the courtroom. Constitutional issues are very rarely fought over in courtrooms, but in higher education law, we fight a lot of constitutional issues, which is exciting for me. I enjoy working on the deprivation of constitutional protections, and so oftentimes that's what we'll be fighting over in front of a jury in the appellate system as well.
That's interesting stuff. And I mean, I imagine everything changes a lot too. So you need to be up on recent trends and recent laws and all that stuff when it comes to this.
Yeah, you really do, because higher education law is constantly changing.
Yeah.
We've seen from some have heard of that Dear Colleague letter in 2011 that set up the Title IX major issues. And basically the focal point of that was whether the accused was going to get some due process protections. We had the first set from 2011 through the first Trump administration be pretty light on protections for the accused. When Ms. DeVos was the Secretary of Education, she flipped that and made way more protections. This last Biden administration attempted to wipe those out, restore many of the victims' rights that they felt had been abrogated, but that didn't work out. So now our Title IX work is not as receptive to a lot of legal work because the DeVos rules provided good protections on both sides of the docket. But that's an important thing that we have to do to keep up in higher education law. I'll tell you another thing that is very new and just has come out within the last month is that the Department of Justice, that now, of course, is in the Trump administration, has invited whistleblowers under the False Claims Act to make whistleblowing claims if organizations like higher education are continuing to flout DEI requirements, but under maybe another name. So many of the DEI laws have been changed or stopped. And the Department of Justice, matter of fact, the Wall Street Journal just last week had an article about this, about how the DOJ is inviting whistleblowers to make those reports. And there's some real money in those kinds of issues, because if an institution is found to still be violating those laws and it becomes a false claim, those claims can be $14,000 to $30,000 a claim, and universities, for instance, make thousands of those claims and certifications every year. So that's I think the Department of Justice is just looking for help in enforcing the laws as it concerns DEI issues. But this is, for higher education law, we've had whiplash issues basically over the last, 14, 15 years, where we've gone all in one way and then we go all in another way. And now we're back all in the other way. So I feel really sorry for the administrators who are trying to keep up with this and keep their claims, forms current, and their ability to process these claims, because it's really, really difficult. But it's made our work really challenging, and we really enjoy the work in this area, protecting professional students. Title IX work involves, even a freshman, but a lot of our professional students that I work with deal with due process issues when, they're in the fourth year of medical school and they're driven out of school, or vet school, and they're driven out of school for some claim that they cheated or something else. And they've spent literally $500,000 in their education up to that point, and they're just being shown the door. So a lot of what I do too is helping professional students in that circumstance.
Yeah, that's important. All right. Well, thank you for tuning in to Deals and Disputes with West Webb Allbritton and Gentry. To get in touch with Gaines and the firm, visit westweblaw.com, and that is Webb with 2 B's. And don't forget to subscribe to our channel and leave us a review. We appreciate it. Gaines, it's always great to see you. Thanks so much for all the insight.
Thank you. I enjoy it. And gosh, that time just flew by too fast. There's so much more to say in this area. And let me just say one other thing. Get help. Students need to get help. Faculty members need to get help. Staff members need to get help to navigate these waters, because they're difficult and you can't do it alone without some guide to be able to help you avoid the well-worn traps we're aware of.
Sounds like we need to do an episode 2.
Yes.
All right. Well, thanks a lot, Gaines. Really appreciate it. Thanks everyone for listening.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.